A very good morning to all the participants, distinguished guests, faculty members, students, ladies and gentlemen. On behalf of SS Dempo College of Commerce and Economics, the institution's Innovation Council, and the Department of Law, I extend a warm welcome to one and all. This workshop is on intellectual property rights and IP management for startups. Respect for inventors and creators is the key for success of an intellectual property rights mechanism. On this pretest, we have organized this one-day workshop on IPR and IP management for startups. The workshop is hybrid and will be of two sessions that will be graced by our two able experts. We will be enlightening our various modules of intellectual property rights. The first session will be an online session on Google Meet by Sandeep NP from Bangalore on IPR and patents for startups. The second session will be taken in physical mode by Mrs. Suvarna Sulakar on the topic IPR for technology and business. We shall begin with session 1. We have with us Sir Sandeep to speak on IPR and patent for startups. I kindly request Mr. Senroy D'Souza, the student coordinator for this workshop, to introduce the resource person.
Thank you for giving me this opportunity to introduce a speaker, Sir Sandeep. Sir Sandeep has completed the Bachelor of Engineering in CSE. He also holds the LLB degree and has done a postgraduate diploma in IPR laws. He is a registered Indian patent agent. He is currently working as a senior associate at KNS Partners, Bangalore for more than 7 years. Sir Sandeep is involved in patent drafting, prosecution, and filing of patent applications in the areas of computer science, computer networks, embedded systems, artificial intelligence, computer applications and software, medical devices, electronics and communications, and telecommunications. He handles prosecution of patent applications in various countries, including USA, Europe, Canada, China, and Japan. Sir Sandeep regularly advises independent researchers, companies, and startups on issues of patentability, freedom to operate, and conducts patent searches.
Thank you, Senroy. Now I request the resource person, Sir Sandeep, to take charge for the session.
Thank you everyone. First of all, good morning, and hope you all having a great day. I'll be putting up my presentation. Let me know once you can see the presentation. Are you able to see that?
Yeah, we are able to see the presentation.
Okay. Hope you can see the full screen.
Yeah, it's up here.
Okay. Thank you. So let's begin with the topic for the day, that is intellectual property rights and patents for startups. Now, the moment we say intellectual property rights, so the first question that comes into our mind is, what is intellectual property? So as the name suggests, intellectual is the act of mind. It's a creation of human mind, and it is from the intellectual, thoughtful thinking of the person who will be generally called as an inventor or a creator of an invention. The protection for an intellectual property is similar to the real estate property. We would have purchased lands, there would be buildings or any tangible assets that we will claim our rights on. And intellectual property is a similar right given to the intellectual creation of a person. There is no tangible, in most cases, there is no tangible property associated with the patent. But in some cases, there could be products or there could be services and devices which are patented. So it could be both tangible and intangible, but the analogy here is similar to a real estate property because there will be a monopoly given to the person or the creator over the property that he owns. So patent rights, who assigns or who grants the rights over intellectual property? So it is by the government of India. So and likewise, when it goes to foreign countries, the respective governments will grant the rights to the creator or the innovator over the invention that he has found out, the invention that he has created. And each form of intellectual property will have the monopoly or will give a monopoly to the creator for a definite time frame. So it is not eternal. It is not the creator will not have the monopoly over the invention forever, but it is for a limited time period. So based on the type of intellectual property, there will be a limited time period for which the innovator will be given monopoly over the creation. So there are a lot of types of IPRs. So IPR is one broad umbrella under which we have different types of protections. So the first one is trademarks or brands. Trademarks are essentially the logos or they are the face of business, which generally will be used by the companies or individuals to uniquely represent or indicate or showcase their business to a person. For example, logos like the one we have, K&S Partners here. So this itself is a trademark, and this is the trademark owned by the company. The entire logo, its exact look, and other aesthetic appearance. For example, the gray and white combination here, the exact font used here, the size of the font. So everything forms a part of the trademark. Copyrights are essentially the creations which are mostly into literature or artistic work or paintings or music. So all these artistic or literary works are classified under copyrights, and even the program codes or algorithms and flowcharts. So these things will also fall under the category of copyrights. Plant variety is another type of IPR where you will get an invention on the plant variety, on the gene of the plant. Suppose you have combined certain properties from multiple plants or multiple species, and you have come up with a new species altogether, which has certain properties. So such protection or such inventions in the plants or any other vegetables or fruits or any yield. So that will be categorized under plant varieties. Geographical indications uh, are generally related to a specific geographical location. For example, we have the Mysore sandal soaps, or we have illegal saris. So they are all related to a particular geographical location, and they come from the speciality of the land. So geographical indications are always related to the special qualities of the land, which make it difficult to grow or produce this product elsewhere in the country. So they are inherited by the particular features of the land. Designs are again the aesthetic appearance of a product. For example, we have a pen, we have a chair, or there could be a unique design, or there could be a unique design for the water bottle, for example. So all this aesthetic appearance are categorized under designs. Here, the functionality of the design may not be of importance, but the design, how it appears to a person, or how in terms of its appearance, how it is different from other products. So there could be 10 bottles, and if I invent a 11th bottle, water bottle, which is on the appearance different from all other 10 bottles, then I can get a design protection for the design that I have come up with. Patents are one of the most popular forms of IPR, and patents are generally granted for the technology. So we have seen that trademarks, we have seen copyrights, plant varieties. So they all deal with different types of products, and patents are particularly for the technology. So it could be in any domain. It could be in the domain of engineering. It could be in mechanical, or it could be some hardware related technology, or it could be a biotechnology invention. So it could be of any stream, but basically it is given to a technology. And trade secrets are slightly a different form of IPR, which mostly deal with a secret or the business secret of a company. For example, we have Coca-Cola. So the exact mixture of water and sugar and other carbohydrates, which are uh, embedded in the Coca-Cola solution, is still a trade secret of the company, because no, they have not revealed the exact mixture of the solution to the outside world. So it remains a trade secret of the company. So that exact combination gives a particular taste and texture and the physical property to the solution, that is the Coca-Cola or Pepsi, and that forms the major business aspect of the company. So that is why it is categorized under trade secret. So it is the secret of the company, which is very much essential for the business, but it is not revealed to the outside world so that nobody else can copy the product in the same exact manner. So these are some of the forms which can be broadly categorized and into multiple categories. Yeah, so we will see in detail some of the examples for these types of IPRs. The first one is trademarks. As I told, it includes all the symbols, the logos, and even the phrases like broadcast yourself. For example, YouTube always comes with this phrase. So the exact phrase with the exact set of letters and the exact combination will also be covered under trademark. So the term of trademark is for 10 years. That is, once you apply for a trademark and you get a grant on your trademark, that will be yours for a period of 10 years. And after that, every 10 years, you have to file for a renewal. And it can go on until the person is willing to renew his rights. It can go on forever. Copyrights, yeah, some of, as I told, it is related to the literature, dramatic or musical work, and some of the examples are like a CD or a copy of a movie or a master copy of a book. So these are some of the examples of copyrights. And a term of copyright is till the life of author plus 60 years. Suppose I'm the author of, suppose this book, two states, then the term of copyright, and I will be able to prevent anyone else from copying my any part of my book until the life of the author, that is my life, plus 60 years. So even after, for example, the event of death, author's death, the copyrights will still be in force for the next 60 years. So copyrights are one of the longest forms of protection, which prevent the interest of author for a very long time. Yeah, geographical indications are, as I told, they are always related to a specific geographical location or the origin where they are invented. Some of the examples are dazzling tea. So there is a unique aroma or a unique texture to the tea that comes from dazzling, and they are pretty famous. So dazzling tea is a geographical indication. And similarly, we have Tirupati Laddu. So if you have experience, you may not find the same exact size or the texture or the taste and the smell of Tirupati laddu in any other laddu. So that itself is the unique property of this laddu, and that's a geographical indication that belongs to them. Designs, as I told, it is particularly into the aesthetic aspect of an article. So the exact same design, the size of the product, the length, its width, the handle, the position of the handle, and similarly when it comes to other articles like chair, how many handles it has, how many legs it has, what is the thickness of the leg. So all this aesthetic appears are covered under designs. The protection is for 10 years initially, and for every 5 year, the author or the person who has invented the design has to renew it, similar to the trademarks. Yeah, trade secret, again, it's a confidential business information. Some of the examples, as I told, it could be Coca-Cola, it could be KFC, the way, the texture, and the size, the uniqueness in the product that they invent, and which is not known to any of the other competitive firms, other competitors. So, how do you assume company's trade or logic to be a trade secret is when a third person cannot reverse engineer the product and still arrive at the trade secret. For example, if I can take a sample of Coca-Cola and I take it into lab, I do some experiments, and if I'm able to come up with the exact same mixture that the company is using, then such a secret will not be regarded as a trade secret, but because it can be revealed to the public, or the public can reveal it, or find out by means of reverse engineering, or by any sort of experimentation. So if that is not doable easily to a person skilled in the art, or to an ordinary person, then such a secret will be regarded as the trade secret. Plant variety, as I told, it could be a combination of multiple plants and come up with a entirely different variety, or it could be a variety on its own. So it could be a new variety on its own without any combination. So generally, there are three criteria which need to be satisfied to be regarded as a plant variety, recognized plant variety. One is it should be distinctive. The properties of the yield or the properties that the plant possesses, for example, its leaf or the size of leaf. So all this should be distinctive enough, and it should be stable. For example, if we are going for a crop, so we have found out a new rice crop, its yield across the year should be stable. So one year it should not be the case that one year it gives me 1 ton of yield and next year it gives me only 10 kgs. It should not be unstable, but it should be stable enough for the years to come, so that it can be regarded as a recognized and stable plant variety. And uniformity, so it should show uniform properties across geographical locations. If I have a plant variety, its features should be same in Goa, its features should be same in Bangalore and elsewhere in the world. So if it shows that uniformity across the geographical location, except for the minor changes. So obviously there will be changes according to the temperature, the kind of water availability, and the soil. All these factors play an important role. But apart from these factors, if the uniformity is changing from location to location, or from region to region, then that is known to lack uniformity and will not be regarded as a stable plant variety. Yeah, with this introduction, uh, can we identify the type of IP here? Since there is no audience here, I think I'll go ahead with this one. So the Woodlands logo that we see here is a form of trademark because it has the company's name and logo on it, and the color combination green and white. So this remains same, and this is what the company is going to claim. So this is a trademark. And the portrait here, the portrait of Mona Lisa that we see here, is a literary work. It's an artistic work, so it will be categorized under copyrights. And the design of pen drive, what we have here, pen drive or the keychain, so irrespective of its functionality, there is a unique way in which it is seen. So it will be protected under a design. And here there is this car, so it could attract multiple IPs. This could the functionality or the performance of the car could be categorized under IP, patent. And similarly, the design, the look and size of the car can be protected under designs. And similarly, the logo of the car could be protected under the trademark of the company. So these are some of the examples. And this is an example where we say the protection of IPR is not just limited to one type of IPR. For example, let's consider example of a robot which performs a predefined function. The functionality of the robot, the technology behind it will be can be protected under a patent. So the person who has invented this robot can apply for a patent for the functionality that the robot performs. And the backend code or the source code, the logic and the program, which remains same. So there is no change in the program, but as such, it can be protected under a copyright. And similarly, the logos and the taglines that the robot comes up with, so those things can be protected under the trademarks. And the exact design, the design of hair, the size of the limbs, length, the size, weight, everything can be protected under designs. So a single product can attract multiple IPRs, so it can be protected under multiple IPRs. So the more protection we seek, it is going to be a strong IP and more rewarding to the person who has invented. Now, since patents is one of the most important and popular forms of IPRs, we will see patents in in little more details. So, patent is a reward for the inventor. It's an award for the inventor, and a reward for the investor. So, patents are going to help both the inventors, the creators of the technology, as well as the investor, because it revolves on the technology. uh, it involves a lot of capital investment. There is a lot of money and time invested. So obviously, the inventor may not be well equipped with the required resources. So he has to seek help from an investor, from an external investor. So in case of companies, the employees could be the inventor, and the company itself, for example, Samsung itself could be the investor for the invention. They where they enable their inventors, their employees to invent something new. So here it's an award given to the inventor as well as a reward for the investor. So in what terms it is rewardful, or it is rewarding to the investor, we will see in the next few slides. So patent is a monopoly given for 20 years. So this is called as the term of patent, which is for 20 years. And it is generally used for the commercial exploitation of the technology. Suppose I'm the inventor and I have invented a new technology, for example, call my friend over a telecommunication network. Then that technology I can commercialize it with the network operators, for example, Airtel or Vodafone, or any other network operator. So I can take my invention to them and I can sell my invention to them for a commercial value. So this is called as commercial exploitation of the invention or the technology, and this is kind of rewarding as well as awarding for the investor and the inventors. So why it is essential, or why do we need patents? So I can just invent anything. I know it works well. I know it is advantageous to the people. Then why do I need a patent? So why should I go for patent rights? So it is essential for various reasons, and the most important ones are, so as an inventor, I would like to protect my technology, my invention from infringers. So here, infringer in layman's term, it could be any third party who tries to copy my invention. For example, I have, as I told, I have invented a new invention, and my it could be my friend, it could be one of my family member, or it could be my lecturers, my peers. So it could be anyone who has seen the working of invention. They know how the invention works, they know how I have developed the invention. So what they can do, they can go to a commercial party, they can go to a company, and they can claim that they have come up with their own invention and they are going to sell it to the company. So I'm not informed, I'm not aware that my friend is going to sell it to some other company. So I don't have any protection over my invention, and as well I don't have any proof to showcase that it is my invention and my friend has just copied it from me. So these instances are called as infringement, and patents are at most essential tools which help the innovators from avoiding these kind of infringements, or protecting their technology from infringers. And it is also a compensation given to the inventor monetarily, because once I have patent, I get a patent certificate, I get an authorization from the patent office, that is the government, saying I have invented this invention and I'm the sole inventor. And once I have that certificate, I can take it to any company or any potential customer. I can sell my invention, and as a proof I can submit my patent certificate. So only then I'll be compensated for the invention, for the thought I have put into the invention, for the efforts, for the time, for the money that I have put into in inventing the invention, will be compensated suitably. So because each patent will be valued according to its value in the market. So there is no specific value for a patent. So I cannot say my patent is valued at 1 crore. I cannot say my patent is valued at 1,000. But there are various aspects based on which a value of the patent will be calculated in the market, in the outside market, and based on that it will be compensated to the inventor. And as well, it's a recognition for the inventor because he has put in a lot of efforts, money, time, and a lot of thoughts into the patent. So obviously he should be recognized because everyone likes to be recognized for the work they have done, right? So it is a important recognition given to the inventor, and these are some of the reasons why we should go for a patent uh, for an invention that we have invented. Yeah. So when we speak about patent protection, we have seen that it is granted by the government, and there are certain rules and regulations which are to be satisfied for me to get a patent. So the supreme law that deals around patents, that sets rules and regulations for an invention to be classified or recognized as a patent, is called the Indian Patents Act 1970. So this is the supreme law that looks into all the aspects of patent and whether uh, any invention should be granted with a patent or should be recognized as a patent or not. So according to patent law, there are three important criteria which an invention must satisfy to get a patent right. So one is the novelty, that is the invention should be new from any of the inventions which are already existing, and the invention should be inventive. So that is, it should not be non-obvious. Though my invention is new, it should not be non-obvious, or it should not be obvious for a person skilled in the art. For example, I have a pen. So we know that there are pens in the market. Suppose I invent a pen with a torch, so then my invention will not meet the requirement of inventiveness because there is a torch well known in the market, well known to the people. There is also a pen well known to the people. So what I had done, I had just combined the torch as well as the pen. So I have combined the functionality of both the independent products into one product. So it is just obvious because I know the functionality of both the products. I know how they work. I had just combined the functionality into a single product. So that will not give me the protection over inventiveness because it is very obvious for a person skilled in the art. So for a ordinary person to see, okay, he has combined the touch, he has combined the functionality of pen, and he has come up with a new device. So which is, though the device is new here, it is not satisfying the criteria of inventiveness. And industrial applicability is the utility of the invention. So it should not be an invention which is merely in concepts, which is merely on the paper. So it should not be a invention which says, uh, I have a device. If I press a button, it will take me outside, the universe. It should not be such an invention where it is only on the paper, it is only on the concept, and cannot be implemented in reality or in the real world scenario. In such instances, it is known to lack the utility or the industrial applicability. So it is essential for an invention to satisfy all the three criteria. It is not optional, but it should be mandatorily all the three criteria to be satisfied. Only then it will be recognized as a patent, valid patent. Yeah, we've seen further details. What is novelty? It is not known to anybody in the world in the exact very form. So as I told the example of pen torch, so suppose nobody knows the pen torch, the device pen torch in the exact very form. They know the torch in its own form. They know the pen in its own form, but nobody knows pen torch as a single device. So in such case, it satisfies the novelty, but at the same time, it will not satisfy the test for inventiveness because it takes only an ordinary skill to combine the both. And the results are also not extraordinary results because I can use both pen and torch independently to get the required job done. I need not combine them. So it is obvious. And industrial applicability is again, it is a test to know whether the invention that I'm claiming for, is it implementable in the real world, whether it has a usability aspect, whether somebody else can use the product that I have invented, or it is just useless to no one. Yeah, let's see a case study related to patent. So how patent can evolve over the years. So this is an example of fire extinguisher. We would have all come across fire extinguishers. So how do we go for a patent protection for the fire extinguishers? Suppose this is the design and the functionality of a vintage fire extinguisher. Suppose let's consider a fire extinguisher which was in use almost 60 to 70 years ago, or almost 100 years ago. So this is one such fire extinguisher which had a handle, which had a cylinder and all the functionality, but it did not have any knob. So the person, whenever there is a fire accident, he had to literally open the threaded opening here, the threaded cap here, and release the solution onto the fire. Whereas there was, as the product evolved, as the use case and as the necessity evolved, few inventors came up with an improved design or improved model for the fire extinguisher where it had a sprayer. So they, instead of a cap, with threaded cap, there was a sprayer which was fixed onto the cylinder, such that the person can need not open the lid of the cylinder, but he can just use the spray. So because these were the liquids that were used were highly flammable, and they were stored under high pressure, so it was dangerous to open the lid. So that's when there was necessity to make sure that it is usable without opening the lid, and that's when they invented a structure which can spray the solution onto the fire at a close range. But again, this had certain disadvantages, because the person had to the handles were very tight, and the person had to hold the extinguisher very close to the person, because it did not have much of range or much coverage. So then again, the latest fire extinguishers came with an extension which made it easy for a person to hold the extinguisher, as well as cover a wide area of fire, standing from a region which is almost 3 meters away from the fire. So this was the improvement over the years. Yeah, as I told, the invention here is not in the extinguisher or not in the cylinder, but the way the solution can be used, or the way the extinguisher can be used. So it has evolved over the time, and such a improvement over the existing product or existing technology will be regarded a patent, because one, the exact very a product is not known before, and second, it is not obvious because they have went out of the box and tried to solve a real world problem. How can I stand far from the fire and still extinguish that? So that was the problem statement, and I have tried to address a real-time problem in the domain, in the practical scenario, and I have come up with a new design and new functionality to the product. So that's when this can be protected under a patent. So yeah, as I told, the earlier ones had a shorter spread. The extension gave us a long reach and the wider spread. Yeah. So when it comes to protection of IPR, these are some of the questions that an innovator have to find answers to be able to go for any kind of IPR protection. So they should be clear on what are they going to protect, whether it's a device, whether it's a technology, the method or a process of manufacturing the device, or it is a mere code or a copyright, or just the aesthetic appearance of the product. And how do I protect? So what are the procedures to be followed, and what aspects of the invention, what aspects of the technology that I need to cover? So in the previous example which we saw, it is not the entire extinguisher that I can protect. So because it's already known, the exact design of the cylinder and other parts are already known. So the aspect that I'm focusing will be the sprayer, or the extension and the sprayer. So I should be sure on what aspects are already known in the market, already present in the market, and what aspects I'm going to protect in my invention. And what is the liability? So if I protect this, then what will be my liability, and who could be my potential competitors, and whether I'm getting into the space of someone else, some other company. So all these things should be considered. And as I told, yeah, whether do I protect the technology or the aesthetic looks? So as we had seen in the case of robot, it could be both patents, designs, or both patents and designs, or it could be any other forms of IPR. Yeah. So again, this is related to the previous slide. So these are some of the questions that one has to find answers to before they can really assess what form of a patent they are going into whether it's a process patent or a method patent, device patent, product patent, or it should be first place whether a patent or some other form of patents. So until now, we have seen broadly the types of IPRs and the uh, and some details around the patents. What are patents and how do we go for patent protection? So I'll pause here for about 30 seconds to take any questions. You guys can let me know if there is any question. Otherwise, I'll move on to startups.
No, sir, no queries.
Okay. Okay, now patents for startups. So how is it different for a startup when compared to other companies or other individuals? Now again, startup when we say startup is obviously a company, as the name suggests, it is a new company. So it's not there in the market for years to come. It is not there from decades. So it's a newly invented company, newly started venture, where there will be limited resources, both in terms of manpower as well as the capital investment available. And in most cases, they may not even have an office space. So the resources are very limited. Almost in 60 to 70% of the startups, they will have constraints on all possible resources and even manpower, including all sorts of resources. So for a startup, why the patents are important for a startup? Because they need uh, they need to protect their hard work, their efforts which is put into innovation and technology exclusively from other players. Because we know when a startup is newly starting its business or it is entering the business world, so there are a lot of companies which are very well established. They have all sorts of resources, they have all sorts of support, and they have their own ecosystem, and it is very difficult for a startup to get into such a strong ecosystem which is already dominated by other strongest players. So it would be very difficult for them to establish themselves in the at least in the beginning years. So they have to get something exclusively for themselves. They have to have some resources exclusively for themselves, and they have to set a boundary for the business and the kind of technology they are working on. So there should be a kind of protection around the space that the startup works. So for that, they need a form of exclusivity for the technology and the kind of business that they are doing. For that, it is important. The IPRs are important, and as I told, it should they should be able to prevent trespassing or potential copying, because they may not even have the required resources to see whether somebody else is already copying them. So they may not have access to all sorts of technology, or may not have access to the entire range of market products. So everything will be limited. So they have to make sure that their invention and their technology is prevented from other potential trespassers or potential copies. And for commercial gains, as again this is relates to the funding. So there will be limited funding, and they should find ways to attract investors. So most of the startups will need help from external investors or angel investors, wherein they allocate some funds, or they will be ready to invest in the company, provided the company shows some sort of promise or some sort of assurance in terms of its technology, as well as the product it has and the kind of business it can make in the near future. So how can it showcase is one thing by the IPRs again. So suppose a startup has 5 patents related to a technology, and it can showcase that it already has a patent, it already has a new technology or inventive technology which no one else in the world has done, and they are the ones to do it first. So they already have a monopoly over such a technology. And suppose as an investor, if you are going to buy my technology, if you are going to invest in my technology, and you will be equally benefited, because I'm going to share a larger chunk of the market, because nobody else has done a similar invention, or nobody else has released a similar product into the market. So I can easily showcase and I can easily convince the investors. I can even go for licensing, so I can work along with other companies. So we have seen a lot of mergers and acquisitions a lot of startups being acquired by the larger companies, because the startups might have a lot of innovations, they might have a lot of new technologies, they might have certain patents. So what the larger company will do, they're not ready to let go of the startup, or they let go of the new technology that the startup has. So they will offer certain licenses or mergers to the startup, and if both the parties agree, then it will go for mergers and acquisitions. And as I told, yeah, attract investments and industry recognition. So other thing, as we had seen, it is very essential for a company to establish itself and get a recognition, its own recognition in the market, so that its business improves, and also customers will be able to recognize the company. So this we see, with the help of a small example. Suppose me as a customer, I go into some shopping mall. I see three products. I want to buy a monitor for my house, for my personal use. I go to a market. I see that there are various types of monitors available. I see first one is a Samsung monitor. I see there is another XYZ company. There is a monitor. There is a Sony monitor. So which one do I prefer? So my natural instinct would be to go for a product which is well recognized in the market, which has a proven track record. So it could be either Samsung or Sony, according to my preference, according to the things that I have heard from social media, or from of my friends, or my prior experience with a similar product. So my first preference would be either of these two, because I already know these two names, these two brands. So this is the recognition both Samsung and Sony have in the market. On the other hand, the XYZ company, which could be a startup, which could be a new player in the market, might have a very good product. So his product could be appealing, his product could be really nice looking, it could have a great aesthetic feature, but still I might not have gone for this. I might still have doubts in my mind about the performance of this particular product, because I don't recognize this product. So this is where the recognition comes into play, and this is where the recognition of a company's products is very much necessity for good business of the company. What are the promotions, or what are the privileges that the government ensures for startups? So the startups are not just let alone; they are well supported by the government, especially with the schemes like Startup India, which are recently started. So there are a lot of benefits, or a lot of advantages given to the startups, even in terms of patents. So the first thing is they have a lot of discounts on the fees. A fee paid by the startup will be as good as an individual, so as good as a natural person, or a person, rather than a company. For example, if a company pays 20,000 for the patent application, one patent application, then a startup will pay only 4,000. So that is the kind of difference a regular company, a big company has, and the startup can and the discount that the startup gets. So generally, the government fees are one fifth for a startup when compared to a regular company. So that is a discount given by the government, and a startup company can expedite its examinations, because each patent application has to go through an examination process. It will be examined by the patent office, so they will see the pros and cons of patent. Only then it will be granted. So a startup can expedite its examination if they have a valid recognition from the startup cell. And certain patent attorneys will be assigned as facilitators to the startups. So government is going to recognize some of the patent attorneys. So these are the attorneys who are well versed with the patent law and patent technology, and they can guide, or they can mentor the startups for filing the patent application. So government itself has allocated over 250 facilitators, patent facilitators, whom the startups can directly approach and seek their advice, and get mentor from them free of cost. So this is another advantage given to the startups. And eligibility criteria, this is again, a company will be recognized as a startup provided it is younger than 10 years. So it has not completed 10 years from the time it was registered. Its annual turnover is not exceeding 100 crores in any financial year, and it is working towards innovation, development, improvement of products, or business models with high potential of employment generation and wealth creation. So any of these fields, if the company is working into or looking into, then there is a high chance it can be given a status of a startup. The who will give the status of or the recognition of startup? It is from the Department of Promotion of Industry and Internal Trade, the government of India, who is going to recognize and issue a certificate of recognition for a startup company. And again, how do we prove that we are a startup entity? Is by submitting the certificate of recognition to the patent office, saying we are a startup entity and we are eligible to claim the benefits that the patent office provides to a startup entity. Yeah, so this is a general life cycle of an innovation. So an innovator or an inventor or a group of innovators come up with an invention, they go for patent protection, they file a patent application with the Indian Patent Office, and there is a competitive advantage because I have already claimed for the right patent, exclusive patent rights. This gives me a competitive advantage over my competitors or the peer companies, and I have the advantages of commercialization. I can scale up my business. I can go for mergers, acquisitions, or licensing of my technology to any other company. So the commercialization will obviously help improve my revenue. So it will just improve, or the kind of revenue generation will be improved because of the technology and because of mainly the commercialization and licensing that I go through. And once I complete these steps, I will get a good recognition in the market as an inventor or as a company. Then it will only help me attract more investments from the third parties, from potential mergers, or even from the customers, because my products are well recognized in the market, and with that I will be able to increase my sales as well as the investment, the return investment that comes into my invention. So this is a general life cycle of an innovation or an invention, and generally the IPRs are associated. So this is not just limited to patent protection, but it could be any form of the IPR that we just saw in the earlier slides. I think I have covered the topic for today, so I'd be happy to take any questions, anything related to patents or provisions for startups or any other forms of patent. Hello.
Yes, sir. In case there are no audiences currently, because we'll be uploading the video, so
Right.
there are no questions or queries yet.
Right, right. So no problem. So I have left my email ID as well as contact number.
Yes.
So they could even reach me on my email or even WhatsApp me on the number. So any questions or any clarifications, I'd be happy to address. So they can even ring me up directly. They can call me and I'll be able to help with that. Or suppose you would like to reschedule the presentation for a later date when there is a good time for the audience as well. So even that should be doable. So you can just let me know in advance by
We'll be
almost
doing
2 to 3 days.
we'll be doing that for the next academic year.
Sure, sir. Sure, sure.
Because students are busy and that's why they are like not able to come. So
Right, right,
next we have the IIC session. I
right,
be
right,
one of the committee. I mean the
right,
same.
right.
Under that we are taking this. So in next quarters when we are going to call you again. For,
Sure, sir. No problem. No problem. So I'll be happy to do that. You can just let me know in advance by 3 to 4 days, and probably if any specific topic that you would like to cover, then we can as well take that.
yes, yes, sir, definitely.
Okay.
Thank you, sir, for
Sure.
your insightful thoughts. We'll be uploading the presentation on our YouTube channel, which will be beneficial for our students. So thank you once again, and here we conclude with our Google Meet, and have a great day. Thank you.
Thank you. Thank you so much for the opportunity. Have a nice day. Bye-bye.